In this episode, we turn to general-purpose AI models, the foundation models behind tools like ChatGPT. The EU AI Act introduces a new regulatory category, general-purpose AI models, or GPAIs. These models train on large data sets and perform a wide range of tasks across different applications. Think of OpenAI's GPT-4 or Google's Gemini. Chapter 5 of the Act sets out specific obligations for GPAI providers. Article 53 establishes baseline requirements, technical documentation, transparency about training data, copyright compliance, and energy consumption reporting. But the Act goes further for models that pose systemic risk. Article 51 defines systemic risk models as those with high impact capabilities, measured either by computational power exceeding 10 to the power of 25 floating point operations, or by equivalent capabilities that the Commission identifies. Article 55 imposes additional requirements on systemic risk models. Providers must conduct model evaluations, assess and mitigate systemic risks, track serious incidents, and ensure adequate cybersecurity protections. The Act also creates codes of practice. Article 56 encourages industry to develop voluntary standards that go beyond the baseline obligations. The European AI Office can endorse these codes and make them presumptively compliant. So why does this matter for your practice? Most lawyers interact with general-purpose AI models daily through contract drafting tools, legal research platforms, or client communication systems. Understanding how the Act regulates these models helps you assess vendor compliance and data protection risks. If you advise technology clients, the distinction between baseline and systemic risk obligations becomes critical. A client developing a foundation model needs to know whether their model crosses the threshold for systemic risk classification. Here's the practical point. The Act does not regulate AI use as heavily as it regulates AI provision, but lawyers still need to verify that the tools they use come from compliant providers. Now, let's look at the phrases we just covered. 1. The Act introduces a new regulatory category. Introduces a regulatory category signals that the law creates a distinct classification with specific rules attached. 2. These models train on large datasets and perform a wide range of tasks. Train on datasets and perform a range of tasks are core AI terminology that legal professionals must know. 3. Article 51 defines systemic risk models as those with high impact capabilities. Defines X as Y is a fundamental legal construction. It tells your audience exactly how the law establishes boundaries. 4. Providers must conduct model evaluations and assess systemic risks. Conduct evaluations and assess risks convey active compliance obligations in technical language. 5. The Act does not regulate AI use as heavily as it regulates AI provision. This comparative structure, not as heavily as, allows you to draw distinctions between regulatory approaches. Time to practice. Repeat after me. The Act introduces a new regulatory category. These models train on large datasets and perform a wide range of tasks. Article 51 defines systemic risk models as those with high impact capabilities. Providers must conduct model evaluations and assess systemic risks. The Act does not regulate AI use as heavily as it regulates AI provision. Well done! In Part 4, we cover enforcement and penalties. What happens when companies fail to comply? Until next time, keep practicing. My work focuses on helping lawyers succeed in cross-border and EU-level legal environments where English isn't optional, it's strategic. You can learn more at thewinningbrief.eu.